yesterday, so that I can describe...
Be on the front foot? Sure.
On the front foot, and then questions can follow rather than toing and froing.
Go for it.
I should mention in respect of one of those issues is that a person was named during the proceedings. Now, I have to be very careful because my legislation constrains the release of information once I have it. So unless the committee require me to, I don't propose to identify the person by name, but simply refer to them as their questions arose about them yesterday.
Okay.
Issue, the question raised in respect of the Crown Casino matter. So I thought I would tell the committee what I'm doing in respect of both of those matters. The Attorney-General, the Honourable Christian Porter, referred to me under Section 18 of the Act matters in connection with interactions between the Department of Home Affairs and Crown Casino. And those matters were described in media broadcasts and in media articles, and there have been further of those since. We undertook, as we always do, an evaluation of the referral, which involves an intelligence workup. We then commenced investigations fairly quickly, within the week. We opened the hearing phase of the investigations on the 20th of August, and we are gathering information on a very wide net from relevant bodies, law enforcement and anti-corruption in all the states and territories. We will embark on hearings next week, the next phase of hearings, and they will be public hearings for the first time in ACLEI's practice, and we'll conduct them in Melbourne next week. We've issued a release in respect of that. We've engaged on social media, but I'll repeat the request that's contained in that release, which is for any members of the public or indeed any members of any organisation that is in possession of material that they want the Commission to know about. We'd invite them to contact us, and if they go to the website, they'll find different mediums by which they can contact us, and that can be done in confidence with the full protections that are provided under the Law Enforcement Integrity Commissioner Act. The second matter relates to a set of complaints made by a person in immigration detention. I understand that the Department of Home Affairs have written to the committee today correcting an error that was on the record yesterday. What I can tell the committee is that that particular person raised two matters. One indirectly came to us through the Department of Home Affairs in what's called a Section 19 notification, where the Secretary must inform me of any matter that raises a corruption issue. So we received that in March and we sent it back on the 2nd of April. We received another one, this time directly from the person concerned, in June, and we again turned that around very quickly. It came in late June and we sent it back to the department in July. Now, why did we send them back to the department? We did so because Section 16 of the Act requires me to direct the resources of the Commission to serious or systemic corruption. In respect of the complaints from this person, we were able to assess them with the benefit of the broader information and intelligence base we have from a series of other operations. And I think this may be helpful for the committee to know, because I haven't made it public before. But in 2016, we became aware of a number of threads that related to potential areas of corruption in both the immigration detention space and in the visa processing area.
What do you mean by threads?
Pieces of information of different types.
Okay.
And you'd appreciate that we receive everything from direct referrals of intelligence reports from his security agencies through to people who ring us in the middle of the night to our hotline and leave messages and everything in between that. Those various threads caused me to seek from government a funding package under the Proceeds of Crime Act to establish what we called the Visa Integrity Task Force. And that kicked off 2017. Now, that involved recruiting a number of specialist people. And as you would probably appreciate, it's not a matter of putting a job ad on Seek or LinkedIn for the type of people that we need. So we couldn't get the funding on the 1st of July and have it running on the 4th of July. It doesn't work that way. So we set about recruiting the right people, and we got them. It took some time, and then we ran that project. I'm pleased to say it's still running because it was so successful that we sought approval to continue the money that we hadn't expended on, and we continue on. And I anticipate we'll wrap it up towards the end of this year. Now, the Visa Integrity Task Force focused on the issue of potential corruption in the issuing of visas, mostly offshore. That caused us to have a very good look at the systems and the people involved in that process. We selected a number of countries. We chose 2 in Africa, 1 in Europe, 2 in the Middle East, and several in Asia. And we went in and had a look at them with a full intelligence workup and investigation process. We disrupted a fairly significant syndicate in one of those countries. We were able to disseminate that information to the relevant law enforcement and security agencies who were able to sweep up those people. In the other countries that we identified, we found a number of corrupt systems and people in place who were entirely what are known as locally employed staff. So they were employees of the Department of Foreign Affairs and Trade, exercising authority under the Migration Act in respect of the issuance of visas. And by and large, it involved the payment of money for a visa which was granted on the basis of documentation that was fraudulent. And whilst it covered the whole range of visas, it was mainly in the student environment because that is the sort of visa that gives you a long-term access to Australia rather than the short-term visa. We're pretty confident we found it all, and we were able to work closely with Home Affairs and Foreign Affairs and Trade. We were able to interdict the syndicates, particularly the bigger one. That resulted in a code of conduct action in respect of the locally employed staff, because as you'd appreciate, the criminal sanctions available to me under the Act do not apply extraterritorially. So what we're really interested in is getting rid of the risk, cauterising the wound so that normal processes can be underway. We then engaged in an extensive educational process in collaboration with Foreign Affairs and Trade and Home Affairs to go and train or retrain the officials in those places in how to go about their business. We think we've got a very good understanding of that visa issuing space in those countries that we looked at. We also had regard to China, one of the largest markets for visas. We assessed that because it was one of the largest markets, and in our consideration of the department's processes, that it was very robust. My hearings that are commencing next week will explore and test that proposition quite significantly. The parallel aspect of the task force related to other operations that we undertook in the immigration detention space. And I initiated an own motion investigation 3 years ago in respect of issues that matters of public consideration arising out of Manus Island. We had a good look at that. We reached the conclusion that there was no corruption issue. Whilst there may be other issues that are criminally related, they don't fit within the definition of corruption provided for in this Act. And it may be helpful if I remind the committee of that definition. It's threefold. The first limb is abuse of office, and you may be familiar with the criminal law aspect of abuse of office. It entails the prosecution proving the element of dishonesty. That's easier said than done on the on the criminal burden of beyond reasonable doubt. So we do that, and we have had several prosecutions of abuse of office. The second limb is effectively obstructing justice or perverting the course of justice. And the third limb is conduct which, having regard to the duties and office of the person in question, amounts to corruption of any other kind. We then looked at the immigration environment. As I mentioned initially, we looked at Manus Island, and we felt that that test wasn't satisfied. I might also mention to the committee that when I look at considering those corruption allegations, the test in the Act is very broad, particularly if you consider it against, say, for example, the state agencies, such as the New South Wales provisions, which run for pages, that were found to be beyond power by the High Court in the matter of Caneen. In my Act, or in our Act, the hurdle is a very simple one. Corruption jurisdiction for me is information that raises a corruption issue. Doesn't say anything about prima facie case, doesn't say anything about reasonable cause, doesn't say anything about reasonable suspicion of the commission of an offence. It just says information that raises a corruption issue. So, as you'd appreciate, that's not a great hurdle for me to get over. Having crossed that hurdle, the next question is, does it fall within jurisdiction? And the Migration Act allows for the Minister to specify, in addition to Border Force and Home Affairs staff, people such as, at the relevant time, the Serco employees who worked as the officials in the detention centres. So they fall within our jurisdiction. So we decided to have a good look at them. How did we do that? First of all, I visited them all myself. You might realise, as I did, that nothing bad is going to happen while I'm there. But it sent a message that we were having a look. We then sent investigators in overtly, made their presence felt. And then we utilised the covert powers that are available to us. We did identify corruption. People on Christmas Island who were prosecuted, in the Perth Detention Centre who were prosecuted, in other detention centres where we were unable to reach the criminal burden, but we did reach the administrative law test of the balance of probabilities, and so we were able to draw that to the attention of the department. I met with the Border Force Commissioner on several occasions and with the senior management staff of Serco. Our intelligence was disseminated to them and they dealt with the people that we had identified. That's been ongoing for 3 years, and I am as confident as we can be that we've put the appropriate resourcing into having a look at the detention centres and the visa issuing process, at least in the countries that we looked at. That included the person who was discussed yesterday, and I understand, I think I've already said that Home Affairs have corrected the record, but we looked at that particular person and we were satisfied that all the intelligence work and the investigative work had been done in relation to the two matters that he had raised, and that in terms of my obligation of serious and systemic corruption, it was appropriate to refocus my resources on that more significant key issue that we referred to the department, and we knew that they were apprised of that. Thank you, Chair, for that opening. I'm available, or we're available for any questions that the committee may wish to make.
Thank you very much, Commissioner. Senator Lambie, you have the call.
Oh, Chair, is there a reason why Senator Lambie is up? Go for it, Jackie.
So, I beg your pardon, Commissioner?
No, it has to go in order. It has to go. Yeah, that's just...
it's just I'm a member of the committee, and generally the protocol's been to give me
That's
a call.
okay.
Look, for the record, I had given the call to Senator Lambie because she's the person who had notified the Secretariat first that she had an interest in this area. But you are a member of the committee, Senator McKim, and if Senator Lambie's not worked up about it, then I'm happy to accommodate your need.
That's okay.
The next 10 minutes are yours.
It's okay.
All right, thank you.
It's a bit difficult sometimes, sorry, because we do have to move around. There's only a few officers there, Nick, and Nick's probably got something else on to go, mate.
And Senator McKim doesn't always have a picture of the information that I've got in circumstances where other people have been feeding information all day long about the things that are priorities for them. But in any event, take it away.
All right, thanks. Well, thanks for your opening comments, Mr. Griffin. They've raised a number of questions in my mind that I'll now begin to ask you, and I suspect we'll run out of time in my first tranche, so we might have to come back to it. Look, the first matter I'd like to discuss is the matter that Home Affairs have corrected the record on today. You may be constrained from mentioning names, and that's fair enough, but I'm not, so I'll place on the record that this is in regards to a complaint made by Mr. Nauroze Anees that this committee had previously been told was referred to your organisation on the 6th of March. Could you just remind me when you said you actually referred that back to Home Affairs?
I believe it was the 2nd of April, Senator.
The 2nd of April. Okay. So when Ms Noble from Home Affairs said on the 4th of April to this committee, the Secretary referred the matter to ACLEI on 6 March and it remains with them, that's wrong, is it?
I can only tell you what we did, and that is, my staff checked today, the message containing my letter went on the 2nd of April.
Are you able to provide the committee with a copy of that letter?
Yes.
Are you able to do that in real time, or would you need to take that on notice?
Oh, we need to take that on notice, Senator.
Thanks, Mr. Griffin. I look forward to reading that. Now, in the course of your opening statement, you mentioned I can't remember the name, the task force that was established to deal with, I think you said, potential corruption around, firstly, immigration detention, and secondly, visa processing. Is that right?
I'm sorry, I've conflated the two.
It may be my understanding, Mr. Griffin, so no need to apologise. Perhaps you could just clarify what the task force was investigating.
Thank you, Senator. The one to do with visas had the acronym VITF, and it's the Visa Integrity Task Force.
Yes. And
it was specifically directed to largely the external issuing of visas
offshore.
Outside Australia.
Yes.
Offshore.
Okay.
The second one was a group of operations that were divided up between my teams. So they had separate operational names, but in the end we rolled them all together because they were also related.
Okay, and that was into immigration detention?
Correct.
And did that one include Manus Island?
No.
That was a separate
predated.
Matter. A predated and a separate matter. Okay, I'm going to park Manus Island for a minute, but we will come back to it.
Yes.
So I'm sorry, VITF, could you remind me what that stands for again?
Visa Integrity Task Force.
Thank you. So the Visa Integrity Task Force, when did that, is that still ongoing as of today?
Yes, it is.
Okay. So you said that, so could you just try and encapsulate why you made the decision to refer Mr. Anees' complaint back to Home Affairs? Was it a resourcing issue? I think you alluded to that in your opening comments. Would that be a fair?
That was a significant part of it, and it relates to Section 16 of the Act, which obliges me to direct the resources to serious or systemic corruption.
Yeah.
And as you'd appreciate, there are gradations of how serious something is, and indeed how systemic it is. So it's a triaging process.
Yep. Thank you. But ultimately, what you've done is refer complaints made against Home Affairs back to Home Affairs for investigation, haven't you?
Yes.
So you've basically, by referring it back, you've initiated the department investigating itself.
Yes, I have.
Okay, but you've said that you have oversight of the investigation?
Correct.
All right. So firstly, why was Mr. Anees not told that the matter had been referred back? I've just checked with him. He's got no idea. This is all new. He's watching, and this is all news to him.
We typically don't engage with people who have referred matters to us in the first instance, particularly where we've taken the decision almost straight away to refer it to the agency. The Act actually comprehends that agencies really have the first responsibility for the maintenance of their own internal integrity, and it's a fine balance because you've identified one of the issues, which is sending something back to the people who an individual may conclude, well, these are the people who've done this to me.
My word.
Why have they sent that back?
My word.
And I fully appreciate and understand that, yes. What we did do, and what we have done consistently in those particular centres, as I adverted to earlier, we, if you like, showed the flag. So I went there, people who were there.
So this was in the context of that complaint or the broader work?
No, the broader one.
Yeah.
Yes.
So I'm just specifically trying to ask questions about the specific complaint.
Yes.
And in fact, you said, I think in your opening statement, there were actually two complaints referred. Were they both referred by Mr. Pizzullo?
No, one came directly from the gentleman in detention.
Yes.
Himself, and it was about himself. Mm-hmm. The first one wasn't about him.
I understand that. Why did you make the decision then, Mr. Griffin, not to simply... well, actually, I'll ask it this way. Wouldn't you agree that I don't know what the second complaint was, but I do know what the first one was, and it was a matter of visa integrity, was it not?
Yes, it was.
So why didn't you ask your task force, which was in operation at the time, to investigate that?
Because it was part of the total package that we're investigating. we were looking at allegations in relation to the payment of bribes for the processing of visas.
That was sorry. Are you speaking there? Sorry, Mr. Griffin. Are you speaking there about that specific complaint or the broader work of the task force?
We captured that specific piece of intelligence into the broader work of the task force.
But if this might be a silly question, and apologies in advance if it is, but if the task force was up and running and ongoing, surely the resourcing issue wasn't a huge one for you, because you already had a task force investigating visa integrity. Then another complaint came in right in the scope of that task force. Why was the resourcing such an issue in your mind?
Because at that time, and indeed throughout the period since 1 July 2017, we had chosen those countries offshore with a vast volume of visa processing. We had looked at the particular matter that this person had raised in terms of the broad context within Australia of visa processing, and we were confident that we had a good read on the visa processing internally and allegations of, I won't name the geographical area, but there was a particular office that was said to be involved in that. So I had a team dedicated to looking at that office and the full range of our, if you like, suite of powers. And again, because of the triaging process, I've got to look at the greatest risk. Where is the biggest risk? Now, in respect of the person that we're talking about, I was comfortable at the time of the first issue he raised that there was no risk to him because it wasn't about him. So dealing with that aspect of risk for a whistleblower, if you like, which we take very, very seriously, is my experience of in excess of 100 hearings that I've done as the Integrity Commissioner, that whistleblowers don't want to be known. They are fearful, often with very good reason. So we take that seriously and we protect them. In that first matter with that person, he was not at risk on all the indicia that we had. The second matter, we had already gone into that particular place, and that's where I mentioned to you that we'd had discussions with Border Force and with Serco about people that we had concerns about who were involved in the management and maintenance of that centre. And we were pretty comfortable that the risk had been removed. And therefore, it was, again, a triaging process that the level of risk and seriousness for that matter was such that we could, with reasonable confidence, refer it to the department.
Okay. I mean, the situation, Mr. Griffin, is that in the matter of Mr. Anees, he'd blown the whistle publicly on his allegations. You are aware of that?
I am now, Senator. Thank you. And I'm not second-guessing the decision to make the person make themselves known, but they might feel comfortable.
Well, in fact,
there are other people who we have to worry about.
I fully appreciate that, and I make no adverse comment in regards to that, but I just want to place on the record that in some circumstances it is possible to conceive that publicity would actually help keep somebody safe. Rather than
I wouldn't
secrecy.
quibble with that proposition at all.
You wouldn't quibble with that?
No.
And perhaps that's where Mr. Anees found himself. I'll tell you, he doesn't feel safe. He's still in immigration detention today, and he doesn't feel safe. In fact, he believes he's being victimised because he's made this complaint. And now I have just found out, after at least 2 manifestly false statements to this committee by Department of Home Affairs officials, once on the 4th of April this year and another one yesterday, we've just found out today that in fact this matter has been with Home Affairs for many months. and yet Mr Anees has not been contacted by Home Affairs. I've just checked with him. No one's contacted him. So perhaps, given you have oversight of the Home Affairs investigation, could you encapsulate where that investigation is at for the committee, please, if that's possible for you to do?
We've made inquiries ourselves, having identified the error. We are in a position to oversight what we understand have planned. So we will do that now. I might also draw to your attention, Senator, if I may, Section 220 of the Law Enforcement Integrity Commissioner Act makes it an offence to victimise any person who raises issues with ACLEI. I will park that alongside what you've just raised with me, and as I will treat it just as any other matter that comes to us. It's come to us in this forum, but we'll give it the appropriate response. I assure you of that.
Thank you, Mr Griffin. I very much appreciate that. I really do. Can I just follow up on one comment you just made? You said that you'd oversight what Home Affairs has planned. Does that mean that they're yet to commence an investigation?
We don't actually know that. We know an investigator is identified. So what we normally do, typically when we oversight, is that we will generally provide our own intelligence workup to the relevant agency. They will develop an investigation plan. They'll run it past our senior investigator who's allocated to it to provide advice and guidance, if you like, on how the investigation unfolds.
But at the moment, you're unable to inform the committee that the Home Affairs investigation has commenced.
I know that they have identified an investigator and that they have taken steps, but I can't speak to the detail of that.
But this was referred back to them in early April, Mr Griffin. I mean, that's 6 months ago, effectively.
Well, that particular matter, I think it's quite reasonable that because it related to the alleged purchasing of visas,
yes,
that matter,
yes, it
was pretty much subsumed in our visa process. I can't say the same about the matter that was alleged concerning the man himself, which is in July.
I understand that. I guess the point I'm making is that on your evidence, it's an inevitable conclusion for this committee that 6 months after you referred the first complaint that was referred to you back to Home Affairs, and yet the investigation appears not to have even commenced. That's a long time for the department to sit on an investigation, particularly as twice, in my view, they've given false information to this committee, albeit one of them has been now corrected, but in a way that's prevented me from asking Home Affairs questions about this investigation because they're not coming back.
I understand the point you're making, but I would go back to the timeline. That first one, which is the 6 months, that isn't about the gentleman himself.
No.
And it is about a matter that quite reasonably could be considered as part of what we're doing in the Visa Task Force. So if you're going to start the clock running, I think it would be from July when we sent it back, the second one. And that matter, and Home Affairs will speak for themselves, of course.
Well, in about 6 months when we get them back in. So are you aware of whether Home Affairs is investigating the two allegations separately or in a combined way? I'm only asking to the level of your awareness about that.
No, I don't know.
You don't know?
I don't know.
All right. There's a lot of new information before the committee, as I'm sure you can appreciate, Mr Griffin. So I'll just move to the investigation you say you conducted on Manus Island. What was, in general terms, the nature of... did you say that was an own motion investigation?
It was an own motion investigation.
Information came to light, or to your mind was enlivened as to the potential for corruption on Manus Island, in the Manus Island RPC, is that fair?
Yep. as you'd appreciate, we take a very close look at all avenues of information, not least being open source reporting.
Yep.
I saw the reporting. I thought that the public would want me to have a look at that.
Yep.
So we did. We did an intelligence workup. We didn't send investigators in. It was an extra jurisdictional matter, but we did a very detailed intelligence analysis of it. And then we went to school on one of my predecessors, Mr. Philip Moss, who was an integrity commissioner. He conducted a review and we had a look at the material that he gathered. And I think, with the greatest respect, Mr. Moss would recognise a corruption issue as soon as he saw it. Having looked at his considerations, our own intelligence analysis, I beg your pardon, we were satisfied that it didn't raise a corruption issue. There are other issues, potentially, of criminality, but as far as the three-pronged test that I referred you to earlier, we didn't feel that it crossed that threshold.
Okay, so what were the issues of criminality that it raised?
My recollection is that there were matters in the press article about potential violence or perhaps verbal violence. I can't recall, I'm sorry, and I would be misleading you if I said I remembered.
Sure. When did that investigation end?
It was before the task force was stood up. I'd have to take that on notice, but I think it was the second half of 2016.
Okay. Do you recall whether it investigated allegations that detention centre staff who were involved in the murder of Reza Barati were flown out of the country before they could be interviewed by Papua New Guinean police?
No, it did not.
It didn't. Okay. Mr. Griffin, is there any way that's raised a number of questions in my mind. Perhaps the easiest thing for us to do at this stage is for me to have a bit of a think about that. There is a process to put written questions on notice through this committee. You are, as you've pointed out, you're obviously operating in accordance with your Act and, other statutes on the books. And I don't want you, obviously, to breach your responsibilities. But I have a number of further questions, some of which I would like to ask tonight. But, Chair, I've had a fair old crack at it, and thank you. And I know Senator Lambie's got questions, but can I just indicate I do have a further tranche of questions for ACLEI.
Okay, well, you've had 15. I'll send the call over to Senator Lambie.
Thank you, Chair. I understand that ACLEI has written to my colleague Andrew Wilkie MP asking for him to reveal the identity of a whistleblower who is the driver for Crown Casino in Melbourne. This whistleblower only agreed to speak with Andrew on the condition he remain anonymous. As you've already pointed out, whistleblowers do not want to be known. Andrew agreed to honour this, as he would. So can I ask, rather than spending time trying to discover the identity of this driver, when do your officers intend to go down to Crown Casino and interview all the drivers? Sure, I mean, you got an ace sitting there. When are you going to go and interview all the drivers from Crown?
In due course, Senator.
And is your office going to do that, or are you going to pass that over to the Australian Federal Police or the Victorian Police?
I'll assess that when we see how big the task is.
Okay, so obviously this is out there. Wouldn't you want to move on this as quickly as possible? The longer, do you have somebody advising you on how to do this the policing way, or are you just using your integrity? So do you have actually someone that's been in the policing advising you on how to tackle these issues?
Oh, yes.
You do?
Yes.
Okay, so what do you think your time frame's going to do before you actually get down to those drivers and actually interview every single one of them? Drivers have a lot to say, by the way.
And I look forward to hearing from them.
That'd be great. So any timeline on that whatsoever?
We typically don't telegraph our operational activities.
Okay, there seems to be a lack of sense of urgency about it, that's all. So I'm just trying to get to is there a lack of sense of urgency, or you just don't have the resources to be able to carry it out?
Well, I'm not sure where you get the lack of a sense of urgency from. We commenced hearings within 3 weeks of receiving the referral, and our investigations have been quite extensive. You would perhaps understand that there are a number of other agencies who are running on this track at the moment, and there are issues of deconfliction. But what we will do is, as we always do, undertake the investigation painstakingly and thoroughly, and we're doing that.
So I take particular note that Crown Casino seems to have some sort of power over the Labor Party and the Liberal Party. So can I ask you, what powers does ACLEI have to investigate members of Parliament? What sort of powers do you have to investigate members of Parliament?
I have the powers under Section 75 and 82 of the Law Enforcement Integrity Commission Act to summon any person present within the borders of Australia to answer questions under oath on pain of criminal sanction for failure to do so, and they apply to everyone.
Have you investigated any members of Parliament yet?
I'm not going to go into the operational details of my inquiry in public, Senator.
There are a lot of allegations swirling around about Crown concerning Victorian Police. Can I ask, what powers does ACLEI have to investigate VicPol if needed?
As I indicated, under 75 and 82 of the Act, I can summon any person in Australia and any organisation in Australia subject to the Commonwealth State legal divide to provide information. I can tell you that we have excellent relationships with all of the state law enforcement agencies, anti-corruption agencies, and we are engaging in gathering a vast body of material from those agencies. I'd go so far as to say it may be the first time that a helicopter view of the material that's held by different state agencies will be considered.
Is it, though, when it comes to people like VicPol and politicians, that these powers will only apply when it is known that laws have been broken, and only then you can start your investigation?
I'm sorry, I didn't quite follow that.
Am I right to say...
Senator Lambie, I'm going to interrupt you there and just caution you not to cast reckless aspersions upon members of Parliament and parties in circumstances where you are lacking in evidence for doing so. And if you have evidence for doing so, I suggest you present it rather than doing what you are.
I'm simply asking about a law, whether or not they can investigate before they know the law's been broken or after, and I have every entitlement to ask that, Chair.
You can ask questions about when laws are broken, but in doing so, Senator Lambie, in doing so, you are making accusations. Senator Lambie...
Are you telling me, what am I doing, breaking the law?
Senator Lambie, you have cast aspersions on parties and members of Parliament. I ask that you do this with civility, focus on the issues, focus less on casting claims for which you have presented no evidence. Focus on the issues and we won't have any problems.
Okay, so I'm simply asking once again, when it comes to politicians and police, or federal police or anyone else, although those three in particular, do you have the powers to investigate before you know the laws have been broken, or once the laws have been broken, can you then come in and you have the evidence that the laws have been broken? Do you then go in and investigate, or do you have the powers to investigate before it gets to that?
Oh yes, we can investigate before the law is broken.
Right.
I should qualify, Senator, my response to you about summoning any person. Summoning any person relates to me being satisfied or having reasonable grounds to believe that they have, or may be in possession or know of information that is relevant to my inquiry. So politicians going about their business in Parliament is parliamentary business, and we would of course respect parliamentary privilege in that regard. Similarly with statutory officials and others under state legislation, their personal knowledge and things that they had done in their non-professional activities, they would be subject to my jurisdiction. But the carriage of their official capacity would be a matter for their state corruption bodies. But we would refer that to the state body.
Oh, okay, that's interesting. So then, given that ACLEI, do you believe that you're actually the best organisation to be investigating Crown? Do you believe that you giving this job, you are the best organisation, and we have a lot of them here in Australia, to be investigating what's going on with Crown?
Well, I think it's helpful to define what my role is, and my role, as referred to me by the Attorney-General, is to inquire into allegations of corruption involving interactions between the Department of Home Affairs and Crown. So anything that is relevant to interactions between Home Affairs and Crown, we will inquire and we will investigate. In respect of Home Affairs, that probably divides into two separate components. One is the Border Force officials who put on their hats and go to the plane and clear the people and look at their passports and look at their luggage and that sort of thing. So those officers responsible for the people coming in and out. Also at the other end, as you heard about the ALOs, the Border Force officers at the departure point in another country, is there any corruption in what they're doing? And the separate and parallel component is the visa process of the officials in China issuing the visas to what we are told are referred to as high rollers, and what happens to them in respect of the immigration officials when they arrive in Australia. Two components and their interactions with Crown. Now, what I would do, and what I would imagine you would expect me to do, is cast the net wide and then draw it back in to see what we turn up and investigate that. And that may involve, where it doesn't involve the interactions between those two bodies, that is, those people in my jurisdiction, to refer that to one of the state or other federal agencies.
Oh, so you're like a private investigator then on the outside. So you go gather as much intelligence what you can, then pass it off to one of the departments and hope like hell, I suppose, that they get the job done. Is that where I'm coming from here? I'm just trying to work out your role precisely.
My role is to investigate corruption.
Yep, and once you have all that evidence, you'll then do what? You'll pass it over to the agency that... I'm just trying to work out. You're more like a private investigator as that sort of such, where you say, I've got all the evidence here and now I'm going to pass it over. I think it belongs in Home Affairs, or I think it belongs with the Federal Police.
I see your point.
What?
I see your point.
There is... Point? Right.
Sorry for interrupting. There is some parallel to the metaphor you've used, except rather than passing it over to the agency, we will assemble that evidence. If we're satisfied that it gives rise to a prima facie case, that is, if the evidence is admissible, we'll give it to either the Federal Police to prosecute, but more usually the Commonwealth Director of Public Prosecutions to determine whether or not a criminal prima facie brief of evidence is there. Failing that, it may be that we would give it to a state law enforcement agency, such as the Independent Broad-Based Anti-Corruption Commission in Victoria, ICAC in New South Wales, or the New South Wales Director of Public Prosecutions. But I'm required, once I reach the trigger point of having what I think is sufficient evidence to give rise to a criminal prosecution, then I give it to those prosecuting authorities who are independent and they make that decision. So it doesn't go back to the agency, it goes to the law enforcement bodies.
Okay, so basically it doesn't go back to the agencies, not ever?
It does if I haven't got a criminal case. So what Parliament decided in the Act was to have a two-step test. Section 142, which comes first in priority, deals with the criminal law. If I don't get over the criminal hurdle, then Section 146 says, okay, have you got a balance of probabilities case here that can be used? You'd be familiar with the Code of Conduct and the disciplinary side of the house. Can this be used to deal with this person under Code of Conduct? And so that's my second trigger point.
Senator Lambie, are you far from conclusion? Because you're over time for the block.
Just a couple more if I can. So, thank you, Chair. So, considering that you can't prosecute or charge, and you're doing the investigation and you'll know it back to front better than anyone before you pass it off because you would have done all that groundwork, do you think that maybe it's time to give you guys more powers to be able to follow that through from beginning to finish? Because, you know, passing case from one person to another is never a good idea.
Well,
especially when it's doing with criminal and visas and what's going on, whether you're laundering money.
well, you'd appreciate that it happens all the time where the federal police do an investigation just as I am, and then they give that to the Director of Public Prosecutions. So it's not an unusual process.
But you don't have the same powers as the federal police do, though. Your department does not have the same powers as the federal police.
I'm sorry, I interrupted you again.
Sorry.
Forgive me, and I didn't hear your question.
Your department does not have the same powers as the federal police. You can't go in and prosecute, and you can't go in and charge, which they can certainly go in and charge and walk that through.
We have considerably more powers than the federal police do. For example, we can compel people to give evidence even if they might incriminate themselves in doing so, which the police can't do. So I can have people in, they'll take the Bible or which other holy book they believe in, or they'll make an affirmation that they will tell the truth, and they have to answer every question, even if it leads to self-incrimination. So yes, we've got considerable powers. The question is, should a body with that degree of powers that takes away all those common law rights, should that body also have the power to charge? And there are many who take the view, as did the framers of this Act and the Parliament, maybe that's a bit strong. Maybe we should have an independent body that decides whether or not to charge. That's the situation as it is at the moment.
Oh, so it would be much easier for everyone if we had an ICAC, a federal ICAC, then here in Australia, that'll clear all our matters up. What do you think about that, Mr. Griffin?
I think that's a statement, Senator, of your view.
Actually, I would have just liked what he thought.
This is a time for questions. You can reframe that as a question, but you can't give a speech.
Okay, so I guess my last question is, would it be preferable to have a federal ICAC in these situations, rather than having what I would say is the next level down? I'm not being please, I'm not trying to be mean there, but if we had a federal ICAC with massive amounts of powers, wouldn't we get much better results?
I think one of the issues that arises foursquare there is, say for example, I was a federal ICAC and there were a state Royal Commission underway, as there is in New South Wales, and another inquiry underway in Victoria. The deconfliction of that would give rise to very significant constitutional law issues. That doesn't mean that's wrong. I just flag that there are a whole range of issues that can arise there, and of course the decision is a matter of policy and is one for government.
Thank you, Senator Lambie. I believe we are going to Senator Henderson now.
Thank you very much, Chair. Commissioner, a couple of questions. Could I ask you, does ACLEI have sufficient powers to investigate the broad nature of the allegations referred to it by the Attorney-General in relation to Crown Casino?
Yes, Senator. We in fact have, as the explanatory memorandum to the Act and the second reading speech made plain, we have the powers of a Royal Commission. So we couldn't have any more power under the Australian Constitution and law. We've got the full suite.
And why did you choose to hold public hearings in relation to Crown?
Thank you for the question. Section 82 sets out a 4-limb test that I have to consider each and every time I've held those 104 hearings I've had to date. So I do this every single time, and I have to look at the 4 limbs. The first one is, does this matter involve confidential issues? And confidential is not defined in the Act, but as you would know, it comes under a whole range of titles: medical in confidence, legal in confidence, psych in confidence, commercial in confidence. They go on. So does it raise an issue of confidence? I have to consider that. The second part of that first limb is, does it raise issues that are potentially criminal in nature? Could there be a criminal offence here? As I understand it, what the Parliament was concerned with there was the primacy of the courts, that an executive function like mine shouldn't run the risk of interrupting, perhaps being in contempt of the court. So I have to look at that. Is there that's a balancing act. So that's just the first limb. The second limb is couched in these terms. Is it possible that a public hearing would create unfair prejudice to the reputation of a person? What's interesting about that formulation of words is the use of the adjective unfair. It doesn't say, would it create prejudice to the reputation of a person? It says, would it create unfair prejudice to the person? Again, not defined, but part of the exercise that I have to go through. The third limb is the public interest in this matter of such significance that it warrants a public hearing? And the fourth matter is any other relevant issue. So looking at those 4 and noting that the referral that came to me from the Attorney-General included reference to at least one media television program and several newspaper articles, the balance, the potential unfairness to anyone, prejudice, particularly the people who will be in the public hearings, is way and truly outweighed by the public interest, because the public have already heard quite a bit of this story. So in the balancing exercise, whereas in the normal course of events, just like the police, we don't telegraph that we're coming. We don't say, hey, there's going to be an investigation. We do it behind closed doors, and we don't want to tip off people. But in this matter, the issue is already over. By and large, the allegations are known to everyone, so any criminality would have found another venue by now, or another avenue, perhaps I should say. So it was that weighing exercise, and I've come down on the side of the public interest outweighing those other considerations.
Can I also just ask you, why did you write to the Australia Institute about their public statements in relation to the Crown matters?
That particular document that was published by the Australia Institute it had so many flaws in it that I felt it was incumbent upon me to bring it to the attention of the senior management of the Institute.
And what were those flaws?
Well, one that immediately springs to mind was it said that we didn't have sufficient powers. In fact, here it is. Error 1, I wrote back to this, said that the first error you made, you've said that ACLEI does not have the full investigative powers of a Royal Commission. And then I set out the explanatory memorandum and the legislation. That was the first one. The second one was that our definition of corrupt conduct in the Act is more limited than the definitions in the state-based anti-corruption commissions. It's in fact the reverse. Ours is very broad, as I indicated earlier.
Yes.
Does the information raise a corruption issue? ACLEI cannot make findings of corrupt conduct, but only referred misconduct to agency managers. Well, that's patently wrong. We've had 10 prosecutions just this year alone where we've made findings of corrupt conduct, and the court has found the individuals guilty of abuse of office or other forms of corrupt conduct, but they're criminal sanctions. ACLEI cannot refer cases to the DPP, but only to the Federal Police Commissioner. Again, almost everything goes to the DPP, either federal or state. So that's just plain really wrong. ACLEI does not have the power to investigate ministers or former ministers, ministerial staff, MPs, government contractors or the judiciary. Well, as I've indicated, the Act gives very extensive powers to question any person who has evidence that is relevant to the corruption investigation that I have underway. And then finally, ACLEI is under-resourced and relies on the AFP to carry out its major investigations. Well, no, that's not true. We use what is we refer to as the concertina model. We're a relatively small agency at any given time, roughly 60 to 65 people, but we bring in resources as we did for the task force. We will second people from a variety of agencies, both state and federal, who then are authorised under my Act and who then carry the full sanctions of the criminal law to protect what they hear and learn while they're working with ACLEI. So we can bring those resources to bear reasonably quickly, and they're quite significant.
Commissioner,
that's what I wanted to correct, Senator.
Commissioner, thank you very much. Thank you, Chair.
Can I have one supplementary?
If it's one, sure.
Okay, just curious as to your statement that you can require someone to give evidence that is self-incriminating. Is that admissible in a court in later proceedings?
With respect, interesting question, Senator. The Parliament clearly decided that the need to gather that information was of such critical importance that it interferes or removes those common law protections. The trade-off is that for that, and it's a significant trade-off, is that evidence cannot be used against the person themselves in criminal proceedings.
Yeah, sorry, that I think is proper. So I just wanted to clarify that's normally the situation for royal commissions and
Indeed, and it's a very important point.
Yeah, thank you.
Senator McKim, do you have more questions?
Yeah, I do. Thank you, Chair. So, Mr. Griffin, I just wanted to start by asking you for whether you have the exact dates that the two complaints from Home Affairs were received by ACLEI and then in each case returned back to Home Affairs.
I'd need to take that on notice if I can. Senator, my recollection is the first one received sometime in March, the second one received sometime in June, and they were turned around in the following month in each case.
And I think you gave evidence earlier that in the case of the first of those, it was referred back to Home Affairs on the 2nd of April. I think you said you'd checked earlier.
Let me just confirm that, if I may. Yes, 2nd of April.
All right, and can I ask, I think you've agreed that on notice you'll provide that letter. Could I also extend that out to both of the letters, so that what I'm referring to there, I should ask, were they referred back by letter? Is that how these things are done?
That's how they're done.
Okay.
Yes.
Could you please provide on notice both of the letters? So each of the letters that referred each of the matters back to Home Affairs?
Yes.
Thank you.
Senator, might I qualify my grandiose statement that yes, we can provide that to you. I would need to just add the qualification that it may require, and I don't know, the redaction of individuals, but given that you've already indicated the person's name, I think that's unlikely.
Yep, all right. Thank you, but my next question does go to individuals, and that's to ask whether the letters were addressed to Mr. Pizzullo, who does have some statutory responsibilities in this area.
I always write to the agency heads.
Okay, so both of those letters would have gone to Mr. Pizzullo.
Correct.
Yep. All right. Thanks. Now, in regards to the current role that ACLEI has on both of those matters, which is to oversight the Home Affairs investigation, I've reviewed the correction provided to the committee today by Mr. Brown from Home Affairs. He says that the matter, and I believe in fact I'm sure he's referring to the first of the two referrals, is currently under investigation, but ACLEI's not aware of that. So what sort of oversight are you running, Mr. Griffin, if there's an investigation underway but your organisation's not aware that there's an investigation underway?
We oversight when we receive the investigation plan. To my knowledge, as advised today, we haven't seen the investigation plan yet.
All right, so Home Affairs says there's an investigation underway, but ACLEI is yet to receive an investigation plan.
And it may simply be the disjunct of time that they commence something and they don't have it. I can't speak for them. What I can say to you is that we are yet to cite the plan.
Do you know, as part of your oversight, when Home Affairs commenced the investigation? I've just realised halfway through the question you don't, because you didn't know that there was an investigation underway.
That's right, we don't know.
Stop answering your own questions.
All right, so the situation is that the person who made the complaint, Mr. Anees, has been waiting patiently since it was made public that the matter was referred to ACLEI in the first place by Mr. Pizzullo back in March this year to provide investigators with extra evidence that he wished to furnish them with that was not part of his original public allegations. So since March, he's been waiting for, 6 months about. I've checked with him. He hasn't heard, obviously, from you, which you've confirmed because you're not investigating. I understand that. That's not an adverse reflection. But he hasn't heard from Home Affairs. So and given that Mr. Anees has alleged to me that he's received death threats inside the immigration detention system, given that he's alleged to me that he was physically assaulted inside the immigration detention centre as a result of making these allegations, what would be your advice to Mr. Anees at the moment in terms of how should he go about making himself safe, firstly, and secondly, how should he provide the further information that he says he has to Home Affairs when in fact they haven't even told him that they're investigating this matter?
Just get the sequence right in my head to answer your question, Senator, as best I can.
Thank you.
And I've just been corrected. The oversight extends to the first matter. And that's because it was rolled into the whole Visa Integrity Task Force. So it may well be, I shouldn't speculate, but it would not be unreasonable for Home Affairs to conclude that because that's part of the Visa Integrity Task Force, and because it didn't relate to him, and he'd given the information, that there was nothing more to get from him. I don't know, and we're oversighting it as part of that.
I understand that, Mr. Griffin, but the awkward position I am in is because of the wrong information provided to this committee yesterday by Home Affairs, which they've now corrected. I've been deprived of an opportunity to ask Home Affairs these questions.
Yes, I understand.
That's not an adverse reflection on you in any way, just to be clear.
But what I can circle back to, Senator, is the issue I raised with you about Section 220, about vilification of people if they make complaints to my commission, and we will take that away from this hearing and consider how we would deal with that.
All right. Would publicly providing false information about someone as a result of them making a complaint fall into the category of victimisation?
It may well do. Section 220 has two limbs, as many of the sections do. One of those is to do with, if I might just refresh my memory, if you bear with me, Senator, while I have a look at the actual provision.
Thank you.
It's in these terms, Senator, a person commits an offence if the person causes or threatens to cause detriment to another person on the ground that the victim or any other person has referred the matter to ACLEI. And it carries the sanction of imprisonment for 2 years, up to 2 years.
If you're unable to answer this, please tell me, but could detriment include reputational detriment? It's
a term that would need to be interpreted in the consideration of the alleged offending. I wouldn't rule it out.
Okay.
Senator McKim, I'm concerned that given the letter we have been provided by Home Affairs, tells us we have a current investigation, I'm just concerned that this line of questioning may prejudice that, and I ask you to exercise appropriate care.
All right, I'll keep that in mind.
Thank you.
Chair, thank you.
Can I ask a quick supplementary?
Yeah.
Just in relation to someone who feels that they may have been, or detriment may have been caused in respect of that last section, I presume they bring that to your attention, and you, in ensuring there's confidence in your organisation, would then investigate that and make a referral if necessary?
It's entirely likely that we would consider ourselves conflicted as if the person was a witness to us, and that we had taken it, and then something had happened to that person, that we would form part of the prosecution or police case. So I would think I would probably refer that to the federal police.
But you would simply look, prima facie, say, look, I think this needs to be looked at by the police, and you wouldn't leave it to the person to go somewhere looking for help.
That's correct.
Thank you.
But these are arrests that you're suggesting would occur as a committee.
No. That was just a question in response to.
As officers are covered by parliamentary privilege as well.
I'm not suggesting that. I'm suggesting that he's had false information made public by Minister Dutton outside the Parliament.
But outside the Parliament.
That's right.
Senators, we're running about 4 hours behind.
I understand
We've got
that,
2 hours to go. Can I encourage brevity, laser-like focus, and wrapping up this set of questions as quickly as we can, please?
I appreciate that, Chair, but I'm sure you appreciate there's been a range of new information placed before the committee this evening that requires appropriate examination. Mr Griffin, thank you. I wanted to just ask, and I am nearly done, for tonight.
We know you're not done for all time, Senator McKim.
Well, no, because I think there'll be a number of questions on notice that will come out of
That's okay.
the conversation that we've had tonight. Mr Griffin, the Manus Island investigation, I think you said it ended in 2016.
That's your
memory. Okay.
General recollection.
Could I ask you to take on notice to provide the dates that started and ended, please?
Yes.
Thank you. And just when you originally raised that investigation in your opening statement, my notes said that there was that an element of that investigation was into obstructing the course of justice. Is that right?
No.
No. Okay. My apologies. But you did say, although you did not believe or that the investigation did not uncover corruption issues, it did uncover issues of criminality?
No, we identified that there was reporting of issues that were potentially criminal.
Potentially criminal?
Yes.
And what did the investigation conclude?
We only made a conclusion in respect of whether or not there was corruption.
So you did not...
We didn't pursue the issues of criminality.
Okay, did you refer those off to anyone else?
No, because it was open source reporting that had already been canvassed in Mr Moss's inquiry,
right.
And we thought there was nothing to add there.
That was in regards to the criminality, the issues of criminality or the corruption?
The entirety of what Mr Moss, considered in respect of...
I'm sorry, so I think I've misunderstood you here. So Mr Moss did his inquiry.
Yes.
Post that, you did an own motion inquiry.
Yes.
So can I ask then that this question, were the matters covered in your own motion inquiry covered or not covered by Mr Moss's inquiry?
Those parts of our inquiry that we looked at that Mr Moss had covered, he looked at the full range of behaviours as I understood it. We focused on was there a corruption issue or issues revealed in that material. We didn't look at criminality per se.
Did Mr Moss's inquiry look at criminality?
Sorry, I can't recall.
That's probably outside your jurisdiction anyway.
Yeah.
So just so I'm clear, your Manus Island investigation, was it associated with the Nauru RPC or just Manus Island?
Just Manus.
Okay. So did your Manus Island inquiry, the course of that inquiry satisfied you that there was no corruption issue on Manus Island?
It didn't raise a corruption issue.
It didn't raise a corruption issue on Manus Island. I'm still a little confused, Mr Griffin, because Mr Moss's inquiry was at least in part relating to potential corruption, was it not?
I can't recall what the terms of reference were, but we were satisfied from what we saw in his report that he had not identified corruption, just as we had not on the open source reporting. Because of his status as a former Integrity Commissioner, we didn't go behind the material that he had gathered.
You simply took it on face value, which I make no adverse reflection on,
Indeed.
by the way.
Thank you.
All right, well, you've given the committee a lot to think about, Mr Griffin, so thank you for your evidence this evening.
Thank you, Senator.
Commissioner, are you able to tender or provide to us a copy of your opening statement?
I think we've got that.
I don't think so.
No, I regret, Chair, because I chose not to make an opening statement, but just to address the two issues.
Look, you're a special person for being able to freestyle their opening statement. You're doing very well. Thank you very much for appearing before the committee, and we excuse you and do so with our thanks.
Thank you, Chair.
Thank you. I now call officers from the Commonwealth Ombudsman to the table.